Hi, everyone. Welcome and good evening, and thank you for joining us tonight. My name is Claire, and on behalf of Harvard Bookstore, I'm very pleased to introduce this virtual event with Stephen Vladeck, who is here with his new book, The Shadow Docket, How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic. He'll be in conversation with Jack Goldsmith. Through virtual events like tonight's, Harvard Bookstore continues to bring authors and their work to our community and our digital community. Thank you for joining us tonight in support of our authors and the incredible staff of booksellers at Harvard Bookstore. We sincerely appreciate your support now and always. Our spring event season is starting to wrap up, but we still have plenty of in-person and virtual events. You can see what's coming up on our website at harvard.com/events, where you can also sign up for our email newsletter and even browse our shelves from home. After this introduction, I will drop a link in the chat to order the Shadow Docket. Your purchases make this virtual author series possible, and now more than ever support the future of a landmark independent bookstore. This evening's event will include time for your questions. If you have a question for our speakers at any time during the talk tonight, you can go to the Q&A button at the bottom of your screen and enter your question there, and we'll get through as many as time allows. The event also has closed captioning available, and depending on the version of Zoom you're using, you may need to enable the captions yourself by clicking on the closed caption live transcript button, which is also at the bottom of your screen. And finally, as you might have experienced over virtual gatherings over these past couple of years, technical issues might arise. If they do, we will do our very best to resolve them quickly, and we thank you for your patience and understanding. Stephen Vladeck is the Charles Allen Wright Chair in Federal Courts at the University of Texas School of Law. He has argued before the Supreme Court, and you may be familiar with his work that has appeared in the New York Times, the LA Times, and Slate. Since 2013, he's been CNN's Supreme Court analyst. He'll be speaking today with Jack Goldsmith, a professor at Harvard Law School, senior fellow at the Hoover Institution, and co-founder of Lawfare. Jack's teaching and writing is focused on presidential power, national security law, federal courts, conflict of laws, international law, and internet law. The separation of powers is one of the first lessons in civics class. The powers and responsibilities of the three branches of government are supposedly equally balanced. It's one of the foundational things about our democracy. Lately, however, the judiciary and the Supreme Court seems to be acting on its own, from issuing rulings from the so-called Shadow Docket to refusing to appear before Congress. In his new book, The Shadow Docket, Stephen explores the ways in which the Supreme Court has increased its use of emergency rulings, changing laws that affect millions of Americans without explanations or public hearings. In fact, nearly 99% of the court's decisions are, as he puts it, unseen, unsigned, and almost always unexplained. It's a major shift and one that has implications for the future of our country and the basis of our government. In the New York Times, Jennifer Salze writes, Vladeck argues that the Shadow Docket is being deployed more frequently and in increasingly novel ways. It doesn't just serve as a neutral realm of case management, and the promiscuous use of the Shadow Docket connects to larger questions of trust. And Publishers Weekly says, this insightful and accessible account raises an important alarm. And so now I'm pleased to turn things over to tonight's speakers. The digital podium is yours, Stephen and Jack.
Good evening and welcome, everyone. Steve, congratulations on your new book. It debuted on the New York Times bestseller list. I looked just before this discussion, and it's still doing extremely well on Amazon, so well that Amazon is a week behind in delivering the books, which means your publisher didn't print enough. So how surprised are you that a book, a very accessible book, I agree, but about a kind of technical corner of Supreme Court practice ended up being on the bestseller list?
Pretty surprised, really excited. I think Ian Millhiser, who covers the court for Vox, put it pretty well last week when the bestseller list came out. He said the book is great and all, but it says a lot about where we are, that there's this kind of, I think, public demand for even a wonky book about the Supreme Court. And I guess, Jack, that dovetails with why I wanted to write the book. I wanted to write this book for a popular audience, not just for, fellow law professors, because I think, even before events of the last couple of months, there was this growing public interest in some of the lesser studied, lesser well-known features of the Supreme Court's work. So I'm just happy to have the chance to, bring that to a larger audience. And I'm a bit overwhelmed by how the book is doing, but also really happy because I guess that means it's kind of working.
Yeah, well, it's a very good book, and it explains sometimes complicated things in really an extraordinarily clear manner that lawyers can appreciate, but non-lawyers can understand. So let's start off. The book is titled The Shadow Docket, but the Shadow Docket is just a slice of the Supreme Court's docket. Let's just start off by talking about what is the Supreme Court's docket.
Sure. I mean, so, for the non-lawyers in the audience, I mean, docket is just a sort of generic term to refer to basically all of the cases before the court. And so the docket is in the old days, Jack, right, the physical, and now the electronic just sort of home for all of the cases that a court is currently supposed to be hearing. So for the Supreme Court, the docket is large. I mean, the Supreme Court gets, from year to year, somewhere between 5,000 and 7,000 cases. And of course, it doesn't decide all of them the way that we tend to think about big fancy Supreme Court decisions. The way we think about decisions, the lengthy signed opinions with pages and pages of analysis, Jack, as you know, right, that's a very small slice of the court's overall workload. In any given term in the last couple of years, it's probably 50 to 60 decisions that look like that out of 5,000 to 6,000 cases. And so the shadow docket is this, evocative shorthand that our friend Will Bode at Chicago, a law professor, coined in 2015 to describe the other 99%, just to describe, the rest of what the Supreme Court's doing beyond and besides the big fancy merits cases that we tend to focus so much on.
Okay, and just to emphasize, the 50 or 60 merits cases, those are the cases that we're reading about now, because they tend to come out in the spring and early summer of the year, and they tend to be on the front page of the New York Times. And until 5 years ago, I would say 5 or so years ago, that is where, and for a long time before that, that is where almost all of the public attention and frankly most of the academic attention was. But there's this other 99% of the docket that you focus on, and a special slice of that. So talk about the other 99%.
Yeah.
I mean, how does the start please by talking about, the court gets 5,000 to 7,000 cases. How does it decide? Does it decide which cases to take? Who decides that, and how?
Yeah, so the 2 points to make, one's descriptive and one's historical. So let me start with the way things are today, and then we can work backwards to how it changed. So today, the Supreme Court has just about unlimited discretion over its caseload. In practice, the justices basically pick and choose which cases they're going to decide. There are a small number of exceptions, but it's like 1 or 2 a year that they have to hear. And so what that means is that a large part of the work, both of lawyers practicing before the Supreme Court and of the justices and their clerks, is sorting through all of the cases to figure out which ones they actually want. The formal terminology for this it's called certiorari. A petition for a writ of certiorari is the vehicle by which someone who has lost in a lower state or federal court asks the Supreme Court to take up their appeal. And, Jack, a large chunk of at least what Will meant by the shadow docket is the unsigned, unexplained orders in which the court grants or denies those petitions, where basically the court is either agreeing to take up a case, at which point it's going to have yet further briefing and oral argument and some kind of lengthy decision at the end, or it's refusing to take up the case. And both of those orders usually have no explanation, no vote count, right? No rationale. That's really the bulk of the shadow docket. Like by volume, a majority, an overwhelming majority of the Supreme Court's dispositive orders are grants or denials of certiorari. And that's where I think, why historically we haven't spent a lot of time talking about it, because it's just been routinized that this is how the court operates. But there are 2 critical points that, sorry, Jack.
Yeah, keep going. Sorry, keep going.
No, but there are 2 critical points that I think put this in context. So the first thing to say is, one, historically, certiorari was not a thing. For the court's first 101 years, it had to hear every case on its docket. And so just off the cuff, we don't talk enough today about the implications for the court of Congress giving it that power. But 2, and this is where the book I think was really sort of motivated, in the last 5 or 6 years, we've seen a smaller subslice of these unsigned, unexplained orders not certiorari, not granting or denying appeals, but rather what to do until the appeal gets to the Supreme Court, so-called emergency relief, that has become much more significant, much more prominent. And so those are sort of the two trend lines that the book tries to open with, to introduce readers to. That first, certiorari is actually not an originalist feature of the court, for better or for worse, and I don't take a position on that in the book. I think folks can have different views, but this was a choice Congress made to give the court all this power. And then second, more recently, the real shift in the court's docket has been in the nature and the types of cases in which we're seeing this other kind of non-merits review, the so-called emergency docket.
Okay, so the emergency docket, I think, is where the thrust of the book is, and that's where a large part of the criticisms are. And I want to get to that. I just want to ask one more question about this other component of the shadow docket. And this is what you were talking about, the court's decision to accept or not accept a case on an appeal through certiorari. So could you just explain, you talked about how Congress gave the court a lot of power in giving it control to decide. It used to be the case that for almost all, in fact, for a while, all of the court's docket, they had to hear every single case that came from the lower courts. Not in every case that came from the lower courts within their statutory jurisdiction. It was mandatory. You outline the process whereby over 100 years or so, Congress gave the court discretion over its docket, but it might not be obvious why that is a huge allocation of new authority to the court. Can you explain that?
Sure. Yeah, no, I mean, it's a really important point, and it's one I try to spend some time with in the book. So, if you think about just remember a sort of how much time do you have to do your job? So by 1890, the last year that the Supreme Court had a completely mandatory docket, Jack, the justices had 1,800 cases pending on their docket that they were supposed to decide. It's not physically possible for 9 judges, even acting however quickly they can, to decide 1,800 cases, with full briefing, with oral argument, with full relief, in 365 days. And so, the idea was that it was not allowing the justices to work well. It was saddling the justices with cases that were either factually or legally beneath them. And it was sort of demeaning the court as an institution. I mean, this is an argument that first President and later Chief Justice William Howard Taft will put a lot of stake into, which is that for the court to be a powerful coordinate branch of government, it has to have some autonomy, which Taft meant in both the docket control sense. The justice should be able to decide what cases they're going to decide, and physical autonomy, get them out of the Capitol, get them their own building, which doesn't happen until 1935. Why is that so important? Because if the court can pick and choose the cases it's going to hear, it has more time to think about what it wants those cases to be. It has more time to think about the direction in which it might want to steer relevant bodies of American law. And it's spending less of its time simply resolving individual disputes. There's this clash, Jack, as you know, between these sort of two camps of what is the job of a federal judge. Is the job to resolve disputes, basically just to be the umpire, and in A versus B, here's who's going to win? Or is the job to declare the law and to hand down forward-looking legal principles that are going to resolve not just the current case, but lots of other cases? And for Taft, the rise of certiorari was a way of, moving the court away from dispute resolution and toward law declaration. And I don't think it's a coincidence that his success in the 1920s immediately predates, Jack, what we tend to think of as the era of modern constitutional law, the 1930s, 1940s, 1950s.
Yeah, I mean, just to make one more point about this, the court became a much more powerful institution, and all the famous things it did in the 20th century, whether you like them or not, left, right, or center, was largely a function of the fact that the court could pick and choose the cases it wanted, and it could decide not to hear the cases it didn't want to hear. And it really gave it a lot greater incentive and just a lot more discretion to decide what it wanted and to steer constitutional law in the direction it wanted.
I think that's exactly right. And, this is Alex Bickel, the con law scholar, will later say, right, that these are the passive virtues, right? That by giving the court the power to decide which case it's going to decide, that's how the justices actually can consolidate their power. It's a bit counterintuitive that a court that does less is more powerful, but we have really 100 years of evidence, right, that that's exactly what happened.
Yeah, it is exactly what happened. Okay, let's move to the core of the book. The core of the book is about the so-called emergency orders docket. So what is an emergency order? What is the emergency orders docket, and what's wrong with it?
So I think it might help to start with a recent example, right? Just to sort of put that might be fresh in everyone's minds.
Maybe the abortion pill example, is that a good one?
Yeah, that's what I was thinking, right? So
Okay.
Folks might remember from about a month ago that the Supreme Court issued a ruling, I think it was on Friday, April 21st, that was the technical name of the rulings. It was a stay. And it was a stay of a ruling by a federal judge in Amarillo, Texas, Matthew Kaczmarek. Kaczmarek's ruling would have, had it gone into effect, revoked the FDA's approval of mifepristone, one of the two drugs that is used in medication abortion, and it would have done so on a nationwide basis. And so the Supreme Court issued this unsigned, unexplained order that prevented Kaczmarek's ruling from going into effect, Jack, while the government's appeal of his ruling works its way through the courts. So the idea here is that it's a temporary expedient. It's a way of basically saying, hey, it's going to take us some time to get this case all the way to the Supreme Court for final adjudication. What should the law be in the interim? Right? Should the law be whatever the trial court judge says it is, or should the law be something different? And so the idea of emergency relief, it's not new, but it's that, right, when there's a trial court ruling that, one, is likely to be reversed on appeal, and two, is going to cause irreparable harm while it's in effect, right? It's not enough to wait for it to be reversed, right? That's when emergency relief historically has been justified. In the mifepristone example, right, revoking the FDA's 2000 approval of mifepristone would have meant overnight, right, the specter of mifepristone being unavailable on a nationwide basis, which could have irreparably harmed, countless pregnant women in states in which abortion is perfectly legal, and in states in which mifepristone is perfectly legally available as a means of producing an abortion.
So let me just tease out a couple of things about that. So the trial judge ruled that the Biden administration the FDA could not implement the rule making mifepristone available. And if there had been no appeals, no going to the Court of Appeals, no going to the Supreme Court, and if that ruling had stayed, it might have stuck and caught and prevented the Biden administration from implementing that rule for perhaps years, certainly a year, maybe more. And this kind of highlights the importance of the shadow docket, because that judge is a conservative judge stopping a regulation from a Democratic administration. It can go the other way around, but the general point is the lower courts can do things that can stop the administration from doing something or allow it to do something. The Supreme Court might not hear it for years. By the time the Supreme Court hears it, it might be too late. There may have been a lot of damage done, et cetera. So the hard question is, in general, about the emergency docket, what should the court do in those situations? Do you think it got it right in this situation?
So this is where I think we have to start getting into some nuance, right? So I think the short version is, I think that the bottom line was correct. Like, I think the government and Danko Laboratories, the other party that was seeking relief, had a compelling case for why they were entitled to a stay. But I think that the fact that we got no explanation from the court as to why they were agreeing is symptomatic of the broader problem that the book critiques. And so just to sort of take a step back, there's a difference, and I think this is a difference that we lose sight of a lot in our contemporary discussions of the Supreme Court, between the substance of a ruling and the process, right? And between sort of what the court's bottom line is and how the court gets there. In the context of emergency orders, what we've seen since 2017 is a dramatic and, Jack, I think, fundamental shift in how often the court is using them, in what kinds of lower court decisions the court is issuing emergency relief toward, in how wide-ranging the effects of these emergency interventions are compared to what was true historically. And this is where I think we get to the hardest part, and this is why I take sort of 2.5 chapters of the book to do it, and where we get to a point where, because the court is not explaining itself, it's hard to understand the rationale for why it just so happens that cases with a sort of pro-Republican valence tend to do a lot better than cases with a pro-democratic valence, right? That because there's no explanations in these cases, the overall pattern of the court's behavior is not just far more aggressive than we've seen before, Jack, but also maps onto and at least exacerbates charges of partisanship on the justice's part.
Right. So let me just play devil's advocate a slight bit here.
Please.
So I understand your point. Your point is basically this is a very important decision. The court decided to allow the Biden rule to go into effect rather than to not go into effect. And it gave 0 reasons for why it did so. But that was typically the way the court dealt with its emergency orders docket. And the reason was, I think, that if it, for one thing, for that 99% of cases that the court says we're not going to hear it, it typically does not provide an explanation. It hasn't since the beginning. And if it had to offer a full explanation every time it even addressed a request for an emergency order, it would spend a heck of a lot of time doing that. So, I mean, what's wrong with the court in this case just saying we're just not going to grant the order? Maybe when they here they actually reversed what the courts below had decided. So it is a context where I think you have called for more explanation, but can the court offer an explanation for every one of these rulings? How much of an explanation do you want?
So I mean, you hit the nail on the head, Jack. I think there's a lot to be said for the norm of not explaining, for example, denials of certiorari, right? That the whole reason why certiorari exists is so that the justices don't have to give the same amount of process and the same amount of deliberation to the cases that they're choosing not to hear. I would say the same, Jack, about most denials of applications for emergency relief. So when a party comes to the court and says, hey, I want to stay, or I want some other form of emergency relief, and everyone knows that the application is not going anywhere. I mean, these are often denied by justices on their own, right, without even going to the full court. I don't feel strongly that those need to be explained. The problem is that when the court is intervening, when the court is granting emergency relief, as in the mifepristone case, and thereby, Jack, undoing not just what lower courts have done, but in almost every case, what lower courts have written, where there's almost always a lengthy, expressed rationale for the lower courts about why they ruled one way. To me, the only reason why the court should not be impelled to write is exigency, that they just don't have time. And that wasn't true in the mifepristone case. And it's not true in most of these cases. There are death penalty cases where I think that's a factor. But, when the court has time to write and it's upsetting the status quo, I think it's incumbent upon the court to write for 2 reasons, right? The first is, I think it's really important that the parties in the lower courts have some sense of why the court's intervening. So back to the mifepristone case for a second. There are 2 possible, well, there are lots of reasons, but like the 2 most obvious reasons why the justices might have been inclined to disagree with Judge Kaczmarek on the merits. One is that the plaintiffs are not the right plaintiffs, that they don't have what we call standing, right? That they can't show that they're the right kind of people to bring this lawsuit. The other is that just on the merits, right? That the FDA's decision was not arbitrary and capricious, that it was not unlawful. Jack, I think it would make a huge difference for how the case is currently proceeding in the lower courts if we had some sense of which one it was, right? If there were 5 or more justices who signed on to even a paragraph that says we don't think these plaintiffs have standing, I think that really has an effect on the lower courts. But the other reason why it's important to write is not just guidance to the lower courts. It's in the writing that the court is actually justifying its exercise of power and its assertion of power. And this is, I mean, as you know, right, historically, the court has pitched its legitimacy as being tied to its ability to provide principled justifications for its decision making. We don't expect the court to provide those justifications all the time. Denials of certiorari, again, are the textbook example. As Jerry Gunther quotes Alex Bickle, we want the court to be 100% principled 20% of the time. But I think that where the court is intervening, right, the lack of justification opens the justices up to charges that I think the book really drives home, that the best explanations for when the court's intervening and when it's not is the partisan valence of the dispute. A charge I think the justices should be the first ones, to be invested in rebutting.
So they should be invested in rebutting that. And I want to get to the larger claims of the court not being principled and politically unprincipled. But just on that example, again, I think I'm using some of your arguments. This is just meant to illustrate how hard this problem is. I mean, there's a danger, and there's a danger you have flagged, if the court had offered some guidance, let's say it had given 3 paragraphs of guidance, and it had said that it doubts that they were standing. That would have been a decision made quickly, without full briefing, without oral argument. The court would have offered its opinion, and that opinion might have had an undue influence on the lower courts in a way that not is violative of some other elements of what you think is important to the rule of law. I think that just highlights how tricky this is, because the court can't take every one of these cases and have a full-blown oral argument. One argument for not saying anything is one problem for not saying anything is that the court doesn't always tip off, I should say, what it thinks if it says nothing. But if the court had issued a paragraph saying we don't think they're standing here, would that have been a valid ruling? And that would have been something that you think should be binding on the lower courts? There wouldn't have been oral argument. There wouldn't have been a great analysis.
So I don't know about
the court's in a bad position.
So I don't know about binding. I mean, binding gets trickier, right? Because
forget binding.
Yeah,
it sends, as you said, it sends a signal about what the court's thinking.
Right. The problem is, I mean, so I want to sort of answer this in two ways, right? One is why I think we're already there, and 2, why I think there's a better alternative. So the problem is that the court itself is already treating even the unexplained orders in a bunch of these cases as precedents. So the book talks in detail in chapter 5 about how the court dealt with COVID mitigation policies, especially when there were religious liberty challenges to COVID mitigation policies in blue states like New York and California. And Jack, there's this series of cases in the spring of 2021 where the court keeps chastising the lower courts, the Ninth Circuit, the Federal Appeals Court in California, for not following its unsigned, unexplained orders in prior cases. So, one sort of reaction is, if they're going to treat the unexplained orders as precedent, let's just own it and actually have some logic. But the other point, I mean, and we've talked about this offline. I really think that the normatively ideal way for the court to handle this is for the court as a court to stop handling it, is to go back to the pre-1980 model, where it wasn't the full court that dealt with emergency applications. It was an individual justice. And it was an individual justice acting what we call in chambers by themselves, in a context in which they were able to provide a fair amount of process. Oral arguments were often held in chambers. The justices would often write in chambers opinions. And so you had, Jack, the benefit of deliberation and consideration without the sort of risk that anyone would confuse that decision with a decision of the full court. It seems to me that that's a much sort of better way to balance the harms here versus the reality of the last 5 years, which is where the court is intervening far more often than ever before outside the death penalty context, where it's intervening in ways that at least appear inconsistent based upon any through line of legal principle, where the interventions are being treated by the justices themselves and by lower courts as precedential, and where the interventions appear to be favoring, in the main, right, conservatives over liberals. Like it's those things together, and there are lots of ways to solve that problem. I think the cleanest one, right, is to go back to the old school.
Okay, so let's talk about, I mean, I agree with your criticism of the court treating unsigned orders as precedent and binding and asking other judges below to interpret those. That was a low point in this episode. Talk more generally, Steve, about, you've been alluding to how this practice has grown a lot in the last 5 or 6, 7 years. Give us a sense of what that looks like, and why do you think it happened?
Sure. I mean, so I should say, I mean, the data here is a real mess because there's a big denominator problem, because there are a lot of emergency applications that just never have a chance, that are borderline frivolous and are clearly meritless. But if you look at applications that have been referred to the full court, that's the usual sort of sign that an application is somewhat divisive. If you look at applications where at least one justice has publicly dissented, right, Jack, we've seen a real sort of uptick since 2016, 2017. As recently as 10 years ago, the average number of grants of emergency relief we'd see from the court in any given term was in the high single digits. And most of those were in death penalty cases. Most of those were last minute stays of execution or orders unstaying lower court stays of execution. So the shift that really starts in 2017 is both quantitative and qualitative. We see more intervention by the court. Now we're seeing 22, 24 grants of emergency relief per term. And we're seeing grants, Jack, that have statewide or nationwide consequences in ways that death penalty cases never did. So in the Trump era, we saw a number of grants of emergency relief that put back into effect nationwide immigration and other Trump policies that lower courts had blocked. In the COVID era, right, we saw a number of grants of emergency relief that blocked state COVID mitigation measures. In the Biden administration, we've seen sort of a hodgepodge of everything, but including, for example, orders blocking the vaccination or testing mandate for large employers. So, Jack, it's both more of these and in ways that affect all of us much more directly. That's been the real shift since 2016, 2017.
Okay, I just want to tell the audience that I have one or two questions left for Steve, and then we're going to open it up to your questions. And if you have questions, please put them in the question and answer box on your screen, and I will look through these questions and ask Steve your question. So now's your chance to ask Steve a question. Just write it down and put it in the Q&A. So Steve, you've been on this beat for 4 or 5 years now. You're the leading critic of the court's shadow docket, especially emergency orders practices. It seems to me that the court has heard a lot of the criticisms that you and others have articulated, and it's actually changed its practices and adopted some of the things that you and others have suggested. In the last 3 or 4 years, the court has sometimes taken cases from the emergency docket, and instead of deciding them on the emergency docket, they shift them to the merits docket, where they have full oral argument, full briefing, full deliberation, full written opinions. They've given, not in the case we just discussed, but in other cases, they have given more explanations, I think, for their emergency order rulings, somewhat lengthier. They've gotten into the standards more, which is something that you think is important, and I do too. They seem to me, this is a qualitative judgment, a little less trigger happy in addressing these emergency orders. There was an important opinion by Justice Kavanaugh and Justice Barrett a few years ago, I think, where I think in their effort to tone down the heat on this stuff, they said we shouldn't be deciding these cases unless they warrant our full review, and that's a way of bracketing these cases. And also, there's just much more publicity on these issues now. The shadow docket is no longer in the shadows. So, have you succeeded in reforming the Supreme Court shadow docket?
I wouldn't even begin to try to take any credit for it. I mean, I have not been the only critic. Justice Kagan has been a very vocal critic of much of the court's behavior, and I think she deserves at least as much, if not more, of the credit. Jack, I guess you hit the nail on the head for me when you mentioned the Barrett-Kavanaugh concurrence in that main case, a case called Doe's versus Mills from October 2021. Because I think, oftentimes we lose sight of the fact that the court is a they, not an it. And so, do I think that Justice Alito has been mollified by the criticisms of the shadow docket? No. Right. Ditto Justice Thomas, probably ditto Justice Gorsuch. But I do think at least some of this has resonated with Justices Barrett and Kavanaugh. And I think it's worth putting into context exactly when that happened. So, the Doe's versus Mills decision came down in October 2021. At the end of this really extraordinary, 6 to 8 week period, where the shadow docket had really, I think, been in the public consciousness for the first time, not because of anything I did, but because of the court's refusal to intervene to block Texas's 6-week abortion ban, bill known as SB 8. Right, this was 10 months before the court overruled Roe versus Wade in the Dobbs case, and you had this remarkable 5-4 decision on the shadow docket late at night on a Monday night in September, where the court had declined to block Texas's law from going into effect. That to me really galvanized public awareness of the shadow docket, public criticism of the shadow docket, public sort of attention being paid to the shadow docket. And so, Jack, I think that's really what helped to, the more folks understood what the court was doing, the harder it became to defend. And I think that's an important part of the story, because what it suggests is that, public education here has a lot of value. because the more that we actually see the court holistically as an institution, maybe the more that we'll actually be able to find other points of consensus about areas for potential reform. On the sort of, has the court healed itself? No. So I think, yes, we've seen less of what I would call the bad behavior of 2016 to 2021, but not none. I mean, so just one really good example from right after Christmas. On December 27th, the court issued this 5-4 unsigned, unexplained order in a case about Title 42. Title 42 is the really terribly named COVID era set of asylum restrictions that the Trump administration and then the Biden administration had put in place at the border. And Title 42 was supposed to expire by dint of an injunction issued by a DC federal judge in December. And a whole bunch of red states tried to intervene to appeal that injunction, to keep Title 42 going. And they lost on the sort of the technical intervention question in the Court of Appeals before a diverse panel, a panel that included Judge Justin Walker, a pretty conservative Trump appointee, because the states, Jack, had their intervention was so untimely. The states unbowed, right, went to the Supreme Court and said, hey, Supreme Court, we want you to keep Title 42 in effect while we try to figure out whether we're allowed to intervene. And the court acquiesced with no explanation, with no rationale, in an application filed by states that weren't even parties to the case. I know that's a lot of legalese for the folks in the audience, but it just seemed to me that it was so emblematic of my charges, right? Which is that it just smells partisan when it's 19 red states trying to keep alive an appeal of a Biden administration policy. And the net effect was that, Title 42 remained in effect for 4.5 months, simply because of an unsigned, unexplained order from the Supreme Court. So, my hope is that those increasingly become the exception and not the rule. And I do think the court has moderated its behavior a lot in the last 18 months, Jack, almost entirely because of Kavanaugh and Barrett. But I don't think I still think they ought to read the book. I don't think we're out of the woods yet.
No, I wasn't suggesting they shouldn't read the book. I just want to make one more small point, and then
Please.
I'll go to the questions. It's really remarkable how much this issue has been in the consciousness of the justices. You have Barrett and Kavanaugh clearly responding to the public debate. You have Justice Kagan being sharply critical and using the term shadow docket as a term of disapprobation and then criticizing the majority's use of the emergency docket. You have Justice Alito giving a speech about it. I think he picked you out as a target, and writing an opinion recently that engaged with the public criticisms. I can't think of another example where public criticism about an issue of the court's procedure has worked its way into the justices' minds and opinions. Is there one?
Probably only in very sort of technical areas of the law. This is my 4.5-year-old daughter has an answer. So, Jack, there are probably some patent cases where some of the public, the sort of the bar's disapprobation made its way into the opinions. But no, I think this is a remarkable example. And I wrote about this in the New York Times last week. I think this is a really remarkable example of the justices responding, I think, positively, right, to public pressure. Even Alito's speech, I have lots of issues with Alito's speech, but I appreciate the heck out of the fact that he gave it. Because if part of the problem is that none of this stuff is being discussed, having Justice Alito out there, whether it's in his Notre Dame speech or in his mifepristone dissent, making the case for his side of it, I think is only helpful.
Yep. Okay, great. So we're now going to go to the audience's questions, and just to remind you, please put them in the question and answer box, and I will go through them and ask Steve the questions. Steve, the first question is, does increased use of emergency relief reinforce the ideological polarization among the justices? So I think the question is about what is the impact of the emergency relief problem on the internal deliberations and relationships in the court?
So, it's a great question. Obviously, the only folks who really know the answer to this are the ones who are inside the building. But I think we can speculate. And, the speculation is until the Title 42 case, it had been, Jack, several years since there had been an emergency application in which a justice to the right of Chief Justice Roberts had joined a justice to the left in dissent. right? I mean, we had really seen a run of cases, hi Bob, in which the sort of the ideological polarization was on display anytime there was a dissent, where the dissenters were always from one side of the court or the other, with John Roberts in the sort of central role that he played, especially between 2018 and 2020. The Gorsuch example, I think, is a weird sort of outlier because I still think that's there. And I think the reason for that's pretty straightforward. The applications that get the court's attention really are the ones that come with, ideological charge. And the ones that come about socially divisive issues with some kind of political, contemporary salience, Title 42 being one of them. And so I think it's a combination of the nature of the cases that get the justice's attention already have that charge baked into them. Because the justices aren't writing, it's easier for them to just vote their policy preferences. And that reinforces, of course, the charges that what they're really doing is acting as partisan political actors.
Okay, so next question kind of builds on that. Whether it is true or not, the Supreme Court is seen as more corrupt than previous courts. Certainly its popularity has declined. Its public approval has declined. What change as a consequence of this public perception, in your mind, would give greater credibility to the court?
So that's it's another great question. I really do think that part of the story here, we haven't talked about ethics at all, but I think that's lurking, right, as sort of another part of the story.
Why don't you just summarize those issues that have been in the news the last 6 weeks, if you could?
Yeah, we've seen this sort of this explosion of stories about. I think shady might be the sort of the most neutral way to describe, right? Allegations of shady behavior by some of the justices, especially Justice Clarence Thomas, who has received apparently lavish financial support from a very, very wealthy Republican mega donor, and has not reported most of it, even in context, Jack, where maybe he was supposed to. Right? I think we already know that he's amended one of his prior financial disclosure forms. What I think all of the ethics kerfuffles of the last 6 weeks have underscored is that the court at the current moment really is of the view that it is its own keeper, and that it really is not up to the political branches to provide accountability. Chief Justice Roberts was invited to testify before the Senate Judiciary Committee about some of these stories, and he declined in a letter in which he invoked both separation of powers concerns and sort of infringement on judicial independence as the reasons why he ought not to testify. And I think that's a really powerful reflection of how out of kilter we've gotten on the separation of powers here. An independent court is not necessarily an unaccountable court. So, insofar as the question is what should change how could the court gain better credibility? I think, Jack, the answer is by leaning into some accountability. Just last week we saw Justice Kagan in a completely boring technical order explaining why she was recusing from a case, something the justices have not historically been very good at doing. Those kinds of steps, not being so publicly critical, right, of attempts to have external accountability, not being so hostile to the notion that the other branches have some role to play, as they had for most of the court's first 100 years in regulating the court. And I think that's not about, Jack, any of the decisions we're going to get in the next couple of weeks. It's not about sort of hitting the pause button on affirmative action or coming out differently in the independent state legislature case. It's about institutional behavior, and the justices, I think, doing more to suggest that they believe accountability is actually part of the job and is healthy for the court, versus the signs we're getting over and over and over again that they just don't think that's appropriate in the first place. And I think the docket is part of that story.
Okay, good. Next question. Do you think the reason the court will most likely not go back to the way you described, with individual justices making decisions regarding the shadow docket, is because some of the Democratic appointed justices would not be able to get a word in edgewise? I think the listener misunderstands the question misunderstands the point you were trying to make.
No, but I think I get the question. The question is, if Justice Kagan, for example, is the circuit justice for the Ninth Circuit, does that mean that she's going to run amok with all of the emergency applications she'd be allowed to decide? So, the answer is it's possible, but at least in the old days, most of the justices, with one notable exception, and we'll get to him in a second, but
We
most
talked
of
about
the
him at length.
yes,
Yeah.
but most of the justices took the view that their job as circuit justice was not to rule how they wanted to, but was really to act as a proxy for the full court, and was to sort of to do what they thought the full court would if the full court was able to assemble. Of course, there'll be close calls where, you know, a justice who might have been on one side of a 5-4 decision, right, will go their way versus the other way. But Jack, that norm held pretty well, really until I would say the last 8 to 10 years of Justice Douglas's career. And the book opens with the long story of the Douglas-Marshall fight over the Cambodia bombing dispute in 1973. But, you know, I think Justice Douglas really was an outlier. And I don't really think that any of the justices on the court today would behave the way that Douglas did.
Well, but
yeah.
let me again play contrarian. The court is not, you know, the court back then had different norms and was, you know, even though they had their divisions, they were seemingly more collegial bunch on issues like this. I'm a little skeptical that individual justices deciding these issues for their circuits would improve matters, because we don't even, as you document, we don't even have a clear sense in a lot of these cases what the right standard is, what standard the court is applying, and different justices think different things. The justices are ideologically have quite different views towards the law. I just think that if individual justices were deciding these things, you might see more dissensus and more confusion. Why am I wrong about that?
You may not be. But, you know, in a universe in which there's some movement back to the individual justice model, presumably there's also some consensus that leads the court back to that model, whether it comes from within or without. And I would hope that that consensus would include a recommitment to the standards. I mean, one of the things that happened, especially in the COVID cases, is the justices just started running away from the standards for relief, which I know it's a technical legal point, but it's actually, I think, an important one. That, you know, you had the sense in these cases that many of the justices were just voting for who they wanted to win, without asking the threshold procedural questions about whether the entitlement to emergency relief had been met. Jack, I don't know how you make that go away without some consensus in the first instance. And, you know, whether that consensus leads to better decisions by the full court or to better decisions by individual justices, either of those would be salutary to me compared to where we are. The thing about the full court, the one thing about the sort of going back to the full court model, I wrote the book, and I wrote most of the book before we actually saw the full court do something it hadn't done since the 1970s, which was hold oral argument on emergency applications. That happened last year in the OSHA and CMS vaccine mandate cases. Jack, if the court wants to, if the full court, if the en banc court wants to commit to the in-chambers process for particularly divisive emergency applications, to hold oral argument, to commit to writing an opinion, that would be much better from my perspective too. I just think that it's less realistic than the sort of the justice in chambers model.
Okay, the reader who asked that question made quite clear that you did understand it, and I was the one that was confused. There's a follow-up, and I think you've addressed this a little bit, but maybe this will give you a chance to talk about that chapter on Cambodia. The question is, if you go back to the way it was before with individual justices making a decision, how do you avoid a situation like the Cambodia situation? Maybe you could tell us briefly what happened there.
Right. So in the Cambodia case, so one of the things that used to be true but isn't anymore is that until 1980, when the court rose for its summer recess, it formally adjourned, which meant that it actually wasn't possible for the full court to act on anything until Jack was back in session, either at the beginning of its next term or in a special term, of which there are only really a handful in the 20th century. And so in the summer of 1973, that wasn't possible. So you had an injunction issued by a federal judge in Brooklyn against President Nixon's bombing of Cambodia. To date, I believe it's still the only injunction ever issued by a federal judge against an ongoing military operation. And the Federal Appeals Court, the Second Circuit, immediately stays the injunction, so it never goes into effect. And the plaintiffs, Congresswoman Elizabeth Holtzman and a bunch of Air Force officers, go to Justice Thurgood Marshall, who's the circuit justice, for the Second Circuit, and they ask him to vacate the stay because everyone agrees the clock is running. The money's going to run out on August 15th, and it's already August 1st. And so there's not going to be time for the full merits appeal. The whole argument is we should just, block this now and then let the money run out on August 15th. And Marshall says no. Marshall says, I'm not going to lift the stay. I'm not going to put the injunction back to effect. The bombing can continue. He says, because this is how I think the full court would rule if it were here, even though I'm sympathetic. Well, the procedure at the time said that if you didn't get relief from one justice, you could go to a second one. And so the plaintiffs fly all the way across the country to track down Justice Douglas at his, shack in the woods that doesn't have a phone. And they get Douglas to literally come down the mountain and vacate the stay, basically put the injunction back into effect, which then provokes Marshall back in Washington to impose a stay of his own, basically to overrule Douglas and to add at the end of his last opinion, by the way, I called the other 7 justices and they're all with me on this. Basically, hey, Douglas, stand down. So that was obviously not a good look for the court. But I guess there are 2 things that are different about today versus 1973. The first is the court no longer adjourns. And so, Jack, the norm today is when an applicant applies to a second justice after losing before the first, the second justice always refers it to the full court. There was just one last week where an application originally to Sotomayor was referred to Kavanaugh, and the court always denies. Right? So no adjournment means you can't have the phenomenon of a second justice overriding a first. But also, Jack, I don't think there's a Douglas on the court today. And that's not a point about liberalism. It's just a point about personality and, sort of cavalierness, right, vis-a-vis the institution.
Okay, we have one more question, and I'm going to add to it for our wrap-up question. The question is, could Professor Vladeck speak a bit more about what an ideal written shadow docket order or grant looks like? How much and what should the court be saying about its reasons for the course of action it's taking? Please address that, and then tell us, if you're a dictator for a day, what else what else do you do to the court, or should the court heal itself? Should it be subject to congressional legislation? What else should be done in your mind to fix the shadow docket? Those will be the last 2 questions.
So I can give a real world example of one that I thought was by the book, even though I disagreed with the outcome. The CDC eviction moratorium case. So I think it's called Alabama Association of Realtors or Association of Alabama Realtors versus HHS from August 2021. This was an application basically to sort of freeze the CDC's eviction moratorium. And, Jack, the court wrote a majority opinion, a per curiam, a for the court majority opinion. It provided, I don't remember off the top, 8 to 10 pages of analysis. It identified the correct standard of review, right? We're asked to issue a stay. Here are the factors we're supposed to analyze. It applied each of those factors diligently and, set forth the analysis supporting each of the factors. And, I just differed with the majority in how it interpreted the relevant statute, section 361 of the Public Health Service Act, and whether it did or did not confer that authority on the CDC. But to me, that was perfect. It wasn't the best process in the sense that I would have loved it if there was more of a chance for other parties to be heard from and to have oral argument. But clearly the court's at least capable of writing, sort of thoughtful, if brief, majority opinions that at least set out the right standard and then faithfully try to apply it, even if I might have applied it differently. So that's an example. To your broader question, if I were dictator for a day, first I would keep my children off of live webinars. But the second thing this is, I think, a broader question about the separation of powers and not just about the shadow docket. The book sort of ends with a bit of a milquetoast assessment of sort of specific shadow docket reforms, because to me, the real reforms we need aren't shadow docket specific. I really try to make the case in the book that for the first 200 years of our history, there really was this robust, ongoing back and forth dynamic between the political branches and the court about the court's docket, about the justice's workload, about the court's budget. Congress pulled all kinds of levers as a way of exerting influence, not over the specific outcomes of individual cases, but over the court as an institution. Jack, you know this, right? Congress prevents the court from even sitting in 1802. Congress keeps cases off the court's docket about Reconstruction. Congress docks the justices a substantial part of the pay raise it otherwise voted to all federal judges in 1964. Just anything in that ballpark, right? If I were king for a day, I would get Congress to remember that, to quote Madison in Federalist 51, ambition must be made to counteract ambition. There's an awful lot of ambition in the court today, and I think in the executive branch, and not nearly enough, at least from an institutional perspective in Congress. And that's where I would focus my temporary but unlimited power.
Stephen Vladeck, thank you very much. Congratulations on your book's success. The book is called The Shadow Docket: How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic. Thank you all.
Thanks, Jack. Thanks, everybody, for coming. Claire, thank you for hosting.
Thank you, Claire.
Thank you again, Stephen and Jack, for a fascinating conversation. And thank you to everyone out there for spending your evening with us. You can learn more about and purchase the Shadow Docket at harvard.com or via the link in the chat. And on behalf of Harvard Bookstore in Cambridge, Massachusetts, have a great night. Keep reading and please be well. Thank you so much.
Thank you.
Thanks, everybody.
Bye.
Bye.